everyone. Hope you all are safe and sound at your place. I, Shweta, a legal intern at LEXIS and Company. Today, we are going to talk about the most contentious topic of these days, sedition. Yesterday, our Chief Justice of India, Anupam, asked central government that is this necessary that after 75 years of independence, is this law really necessary after the 75 years of independence? Let's now discuss what is exactly sedition, what is this law of sedition, what is written under section 124 of Indian Penal Code. According to section 124A of Indian Penal Code, sedition is defined as whenever any person by words or otherwise brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law. There is a very interesting history behind this law of sedition. IPC was brought in colonial India in 1860, but at that time this section was not introduced. It was introduced in 1870 on the grounds that it was dropped from the original IPC draft by mistake, and it became very handy for the Britishers to imprison our freedom fighters whenever they asked for freedom, whenever they voice out themselves. So the very first freedom fighter who was booked under this offense was Bal Gangadhar Tilak. Even Mahatma Gandhi was booked under this act. We have to understand that this act is in contravention of Article 19(1)(a) of our Indian Constitution, and it is one of the most draconian law of our country, as it is cognizable, non-bailable, non-compoundable offence under the law, entailing life imprisonment as maximum punishment with or without fine. According to the report by National Crime Records Bureau between 2016 and 2019, there was a 160% increase in the registration of sedition cases, whereas the conviction rate during this period fell from 33% to 3.3%, which means the conviction rate is very low and the law is misused. The persons who are in authority, who have some power, they use this law to suppress the voice of the citizen. The use of sedition is like giving a saw to the carpenter to cut a piece of wood, and he uses it to cut the entire forest itself. We have to understand that in the Kedarnath judgment, it was held by the Supreme Court that sedition is an offense which can be used only if it excites violence. We have come across many cases of sedition in last few years. In the very recent case, the filmmaker Isha Sultan, who in one of the television show voiced out her opinion and used the word bioweapon for the recent development in Lakshadweep and its draft reforms. Though she took interim bail and was not imprisoned, and later she even apologized for the same, but it was in controversy that she shouldn't be apologized. She should not apologize for the same, as every person has the right and has the freedom to speech and expression. Supreme Court quashed the sedition case against the journalist Vinod Dua. In this case, our Supreme Court said that every journalist is entitled to the protection under the Kedarnath Singh case, which defined the ambit of offence under section 124A IPC. In Kedarnath Singh case, five judges of the Supreme Court made it clear that allegedly sedition speech and expressions may be punished only if the speech is an incitement or to violence or public disorder. Now, as we know that our CTI yesterday made this remark, so we are now eager to know what could be the consequences of it. The CJ's remarks have also opened the floor of debate and introspection on the court's own verdict in 1962 in the Kedarnath case, which upheld Section 124A. So now it is the question, and it is the very topic to know whether the constitutionality of Section 124A will be upheld again or not, or still it will prevail as the offense and will be used by our government or whoever is an authority to suppress the voice of the people. So I hope you enjoyed watching it. I hope you understand something about sedition from this short clip. Thank you for watching.